Welcome to Advocacy Exchange, Navigating Injury Texas Law.
Welcome back to Advocacy Exchange, Navigating Texas Injury Law with Larry Littleton. Larry is the CEO and founding member of Littleton Law Firm, where he helps guide strategy, client communication, and case management across the firm. I'm Lisa Mosby, and today we're talking about what happens when an insurance company starts to question the nature or severity of an injury after an accident. Welcome, Larry. Thanks for joining me.
It's fine. I love being able to talk about what I do for a living. How about that?
Larry, when an insurance company begins to question an injury, what are they actually evaluating at that stage of the claim?
Well, questioning an injury is something insurance companies do all the time. They love to be able to classify an injury quickly. For example, if it's a fender bender, one would get less than $2,000 in property damage, they want to classify as MISV, minimum impact. And as a result, you can only have soft tissue injury. Well, that doesn't actually occur. Sometimes you can have MISD or minimum impact and can have severe injuries, particularly if the individual has had severe kind of problems in the past. We've had cases in which a person had neck surgery and they were involved in an MIST, a minimum impact kind of situation, requiring that the surgery be redone. So there are kinds of classifications insurance companies want to do. They want to classify it as soft tissue only. They want to classify it as something that will heal within a short period of time. So the amount of money they have to pay is less than what the value of the case is. The lawyer's job is to make sure that they understand clearly what the injury is and what's all special about this person, pre-existing conditions pre-existing condition in reference to a former accident or some other kind of circumstances that would cause the individual to have severe impact to their system above and beyond the normal. All of these things will be questioned by an insurance company. The idea of an insurance company accepting the medical records and injury on face value doesn't exist anymore. What happens is when that documents, the medical records and all are issued to the insurance company, it is segregated from the rest of the file and sent to a special analysis. This analysis uses a lot of AI. It uses a lot of what they do, the CPT codes, and allocating those codes and what they think those codes mean and how much they were allocating value to it based on their algorithms. But the lawyer is to make sure they know the full story so that it explains the medical more than just what a simple CPT code says, but something what the real person endured, what really happened to them.
Larry, what tends to lead an insurance company to take a closer look at an injury instead of accepting it at face value?
Closer looks are usually generated if it's a MIST, minimum impact. Closer look is if they're involving an 18-wheeler, large corporate policy, any kind of injuries that are associated with loss of consciousness, a TBI injury, instance, those kinds of injuries are severe. They're very difficult to diagnose. And as a result, these kinds of things have to be handled carefully and they may require extensive review. But we know what is coming. We've had the experience to know that when a certain type of injury occurs, it's going to be scrutinized. So we make sure that the doctor is following the normal protocol. We understand what that protocol is and making sure that the proper tests are completed in order to back what they want to do in the case. So it's not something in where we can just try to convince the insurance company that it's more serious than not. It has to be done by the medical evidence. And we have to make sure that the client understands that, to be patient, and to be able to describe all the things they're going through, particularly injuries that are involving the nervous system, which may take a long time to heal, and sometimes they don't heal much at all.
So, Larry, how do gaps in treatment or inconsistencies in medical records influence how an injury is viewed?
Gaps in treatment can be caused by natural reasons. It can be things that are associated with being what people are. And that is they go on, they have vacations or they get some kid that's just in their family that is sick and they got to go to the hospital. You got some of my folks that have been injured in their neck injury, but they've got to go back to work. They're blue collar. They've got to be able to do the job to earn a living to be able to pay the living expenses. So sometimes gaps are generated because of the circumstances of the client. Sometimes they're generated because of the natural protocol of the medical treatment. And sometimes they are generated by outside forces that the insurance company has no idea about. But our job is to make sure they understand what happened and why.
How do insurance companies distinguish between injuries they take seriously and ones they try to minimize?
Well, generally speaking, the medical protocols and the sequence of treatments are associated with the first doctor's diagnosis and treatment. So when a client, right after an accident, if they go to the hospital and it's the emergency room, later it will be the treating physician, the doctor that saw them. It could be the family physician. And what we tell the clients, if we have a chance to talk with them before that first visit, is to make sure that they describe all of their injuries, even if it is an injury that is not the prominent, it's not the most important problem. Many soft tissue injuries in the neck and lower back do not occur within the first 24 hours. It may be 72 hours before they occur. Sometimes it's usually a bump on the head. They've got a bruise or a bruise on their arm that the doctor notes when they have the initial, but they need to make sure they tell the doctor everything that hurts, but being thorough, because that first initial report is what's going to control much of what happens in the future treatment, as well as being able to tie it into the accident from that first treatment.
And then what role does the consistency over time play in whether an injury continues to be taken seriously as the case develops?
Consistency is always an asset. So the more consistent the treatment, the more circumstances or whatever the doctor requires, wait in 3 weeks, call me back and call you back in 3 weeks. More consistency with the plan the doctor gives, the more consistency with compliance, being able to accomplish everything that the doctor has stipulated. All of those things enhance the value of a case. The reason for it, it takes away an argument of the insurance company saying, oh, well, he wasn't that hurt. He didn't go back to the second doctor's appointment, or he skipped 30 days. But if we know the reason he skipped 30 days is because his company shipped him out to go to West Texas where they don't have any doctors available, and he had to do that or he was going to lose his job. So those things will help with those gaps as long as we understand the full story. And understanding the full story means that you keep in contact with the client. You make sure the client knows it's important, and keeping in communications with you is the way the team is able to accomplish the goal. Proper settlement.
Consistency, timing. Is there a case that you could share with us that kind of walks through a situation where an injury was questioned early on, but later became a much more clear case and it was clearly supported?
Yes, recently were involved in a case where with three vehicles, and the client's injury was to the neck and the low back on the initial. Later on, it became primarily the low back. MRIs were confirming that there was herniations, and the other testing indicated nerve deprivation. The problem in the case, however, is the new after you received that physical therapy, after it failed, and after that set of circumstances, normally you go to pain management. The problem with the pain management in this particular case, after the first visit, the doctor indicated that the proper procedure would be use of doing steroids, and that's injections in the back at different levels, either right or left or through the facet joint, for the purposes of alleviating the inflammation that may be causing the pain and the interference. The problem with that set of circumstances is that this particular client was on a second level of treatment in reference to kidney dysfunction. And as a result, the use of steroids were a contra to all of the treatment she was receiving. Simply put, she had about 50% use of her kidneys. The use of steroids might reduce the immunity system. The immunity system being reduced already would allow for a kidney disease and the possibility of having to have a transplant. So those things we knew from the beginning. and we let the insurance company know that the certain treatments would not be available. We were still successful.
Amazing. Just disclosure, knowing everything up front. Don't hide anything from your attorneys is my takeaway from that answer. Larry, how do questions about an injury start to affect the overall direction of a case beyond just the medical side?
Well, justification of the medical treatment is primarily the doctor's protocol, but sometimes that justification may require an introduction of physical evidence. For example, the photos of the vehicle, testimony of witnesses, the turning of the vehicle, the twisting, of vehicle spinning, multiple impacts, all these kinds of things will add different directions of movement. The different directions of movements cause different injuries. So all of those things can help with explaining certain kinds of injuries, whether they're minor or severe. Sometimes it's related to a pre-existing condition. Some people have had severe injuries or prior surgeries. They get involved in another accident and it makes everything worse. We've even had situations where a minor accident resulted in the necessity of redoing a cervical fusion. So it depends on the client, his history, the circumstances surrounding it. Again, it is the job of the lawyer to know the full story, to present all of the evidence to the insurance company in order to be able to facilitate a proper settlement.
Larry, for someone dealing with an insurance company that seems to be downplaying their injury, what's important to understand about how those decisions are being made?
Well, insurance companies, for the most part, the larger insurance companies use a settlement algorithm. And all that simply means is that they've come up with all kinds of factors, all kinds of things that they think that juries are interested in, that they think will put value drivers in the valuation of the case. And if those value drivers are identified, if they are part of the record, if they are part of the client's treatment and remaining residual pain and problems they're having, then they will give it a proper evaluation in that algorithm. But many of those algorithms themselves have variances, and the variances can be determined by, where, for example, pre-existing condition. A variance can be associated with the age of the individual and any kind of circumstances for the use of certain kinds of medications that can aggravate or prevent the use of other medications necessary for quicker treatment and recovery. Like I said before, you can have situations where steroids are not proper. Sometimes the use of analgesics can cause allergenic reactions. And so knowing those answers to those questions beforehand helps us to avoid certain negative algorithm evaluations. But simply put, the medical records are evaluated by one person in the insurance company. The liability issue is done by someone else. And many times the evaluation and settlement may be done by a third person. So again, you're dealing with a continuum of records and information that hopefully the lawyer has organized and controlled so it flows through the system quickly, efficiently, and to the best result possible for the client.
So, Larry, I'm going to wrap this episode up with one final question. You've been doing this for quite a long time. What's some final guidance that you'd like to share with our audience today?
Well, the final guidance I would give anybody who's involved in an accident is to make sure that you get a lawyer on the case. I know I'm biased, but the circumstances are such that it is so complicated, involving different kinds of computer algorithms to control the evaluation, that you want to get the best return you can. If you don't follow their rules, if you don't follow their circumstances, then it may require you to get into litigation. And then the lawyer comes in and he's trying to patch up things that could have been taken care of early. So the idea of being prepared, being organized, being with a total concern for a full recovery, when you have all those things involved, that's the way the full evaluation will allow for a full recovery as well as a full reimbursement of your losses. The best thing I can tell you is if you've been seriously hurt in an accident, see a lawyer. If you just happen to be near the office, give me a call. I'll be glad to help.
Well said, Larry. Thank you so much for your time today. Folks, that's it for today's episode of Advocacy Exchange Navigating Texas Injury Law. If you've been injured or have questions about how your injuries may be evaluated by an insurance company, the team at Littleton Law Firm is here to help you understand your options. Visit littletonlawfirm.com to learn more. Thanks for listening, and don't forget to leave a review, and subscribe to this show so you don't miss the next episode. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.